Erica Ward and Aaron Ward.
Good afternoon, Your Honor. Steve Otherly on behalf of Plaintiff Fixing Housing, 401k plan.
Donna Tope on behalf of Eric Ward and Erica Ward. Tenants on the lease.
Okay, where are we on this case, folks?
Your Honor, so the last time we were here, if you need me to get into that, you denied defendant's motion to stay the eviction.
Correct.
And transfer the eviction case to the circuit court. You ordered tenants to produce a full accounting with receipts of money placed into Ms. Tope's escrow account.
Yes.
And of transactions made for repairs and purchase of supplies. You also ordered prorated November rent and rent going forward into escrow.
Correct.
We had a hearing on Wednesday on the circuit court action.
Yes.
And as you recall, plaintiff or tenants brought the circuit court action. We filed right away a motion to compel payment of rent. And the circuit court denied our motion for lack of jurisdiction, basically leaving it for you. Your Honor.
They did?
Your Honor, we don't.
Who was that?
Judge outside.
Okay, thank you.
She's retiring.
Pardon?
She's retiring.
I understand that.
Yeah.
But,
She didn't want it.
no,
Your
that,
Honor.
no, never say judge outside never wanted to deal with it, because that's not it at all. If she felt this court had jurisdiction, that's what she felt.
Exactly. Your Honor, I have the transcript from Wednesday's hearing, if you'd like that.
I may need it, but hold on. So that was denied, and so the rent issue is now planted firmly in my lap.
In this court, correct.
Okay.
We can go into the accounting if,
Do I have an accounting?
Yes. Filed it on Monday. With receipts. November 10th. With receipts, and the last page is the final accounting as of that date.
This is the one with the invoices attached.
Yes. You asked for,
Oh no, I know what I asked for, but go ahead. What were you going to say with regard to the accounting? I see this document. Go ahead.
Your Honor, one procedural point. We only received a copy of the accounting because it was e-filed in the circuit court. So I would say service would be improper for the accounting for this court. But I would say to be frank, the accounting is a mess and it's wholly inadequate. I have many questions for Ms. Tope, which I think really highlights the problem here that opposing counsel has inserted herself into this litigation. As the court correctly stated last Friday, there's no legal authority allowing opposing counsel to handle and disperse these funds to contractors and for supplies, especially when these funds were owed to my client under the lease.
Hang on a second.
Yes.
Ms. Tope,
yes,
I'm going to ask you a difficult question. I may stop you from answering at some point because I'm not trying to bait you into anything. But these individuals are your clients who, and you're their attorney. They, at some point, gave you funds, right? Were the funds placed into your IOTA?
No.
Oh,
Can
got a whole other problem. Because,
Your Honor,
yes,
let me start at the beginning.
no, you're not going to start at the beginning.
Your Honor,
Because, no, you're not going to start at the beginning.
this,
Miss Tope, you know what? You say, oh my goodness, one more time, and I'm going to find you in contempt.
sir,
I'm stopping you from committing a grievable offense. That's why I told you at the very beginning that I may stop you after my answer, after you gave the answer. Because you have a tendency, when I ask you a yes or no question, to continue to go on and on. And you are going to get yourself in serious trouble. Very serious trouble. I ask specific questions for very specific reasons, because at some point, here's going to be the problem, Ms. Tope, and I'm just going to lay it out this way, and I'm going to try to lay it out without placing any sort of finding or what I'm thinking. If you, as an attorney, are given funds by your client, you must hold those funds in trust. That is typically done through an IOTA account, particularly if you are then dispersing your client's money on their behalf to third parties, to others, or court, whatever it is. You then have to have an accounting of that. Moreover, when I start looking at the dates, at some point, these would be required to be reported. Yes, I'll just leave it there. You're going, this intake and disbursement, on the face of it, had to be done in a particular way. Now, there may be something about the transaction that I don't know, but on the face of it, that's what it looks like.
I totally understand what you're saying. Our case filed before the circuit court was filed on July 9th. They had jurisdiction of that breach of lease case. Part of the breach of lease case was that the landlord did not make necessary repairs for the health and safety of all those who were benefited by the lease. We notified them in that case that we would withhold that. They had been requested to make the repairs. They had declined since 2023. We had to make them for the coming winter for the horses and the people that were there. We notified them in August that they paid the rent in July. We notified them in August that we were going to withhold rent and make the necessary repairs themselves, mitigating, trying to correct a problem. They filed their summary judgment here in this court, which I agree, under a summary judgment, a trust fund would be set up. When they filed on October 20th, this was after months of making repairs.
Stop.
That's when this court got
Getting things confused.
Pardon?
Getting things confused with what I'm saying and with what you're trying to argue.
Mhm.
I get with reference to any escrow court initiates.
We asked for them.
It's what you did before that, Ms. Tobe, that I see as being problematic. You're acting as an attorney, and I'm just going to say this again, and you take into your possession client funds and then disperse them. So I'm going to put it in the most general sense I can. That has to be done in a particular way with certain accounting that comes with that and certain accounting that must then be reported. What is, well, I'm not going to say it's clear to me because I will say I have very serious concerns as to whether or not that happens or happened. Which, Ms. Toe, may, I'm not saying it will, may subject you to certain liabilities, potentially with the state bar.
That would be because of the circuit court case.
So, I'll be honest with you, I'm not the one that you're going to have to explain it to. I mean, but I'm doing my best to say that on the face of what I'm seeing, you may be in jeopardy of some adverse consequences because of what's occurred. That's what I'm saying. What I'm also saying, it's troublesome from the court's perspective because when you refer to you and your clients and certain things that have been done, and this is what happened, and I hate bringing up other cases with reference to present cases, but you keep referring to we, in terms of your clients and you acting. Sometimes that is absolutely appropriate, and I don't it just is. It's just language. Part of the court's hesitation when you are saying it that way is that, and again, I'm saying this and I'm not making a finding, but if you were operating, I'm going to put it in form of hypothetical, and I hope you can follow it. If your clients were following your advice to place the monies with you and then pay the money out, where that may be in violation of the plain language of the lease, right? They may have a claim, whether they choose to pursue it or not, as to you.
I understand what you're saying.
And so that's a problem for the case proceeding because you can't be, you're representing them, but as to the position that they in the business should take, on the face of it, when I look at it, you have a conflict in terms of that.
Okay.
And outside of the fact of the first thing that I said, where you might be in violation, and I'm not saying you are, and I hate even making the accusation, of ethical rules that would apply to attorneys taking clients' money into trust.
I understand.
And again, I will give this blanket statement. I am not saying that, making any accusation. I'm not making any finding. I'm not saying any of that. I'm not saying, even to a great extent, my analysis, if I were to come down to the end of it, is correct. All I'm saying is that's what I see on the surface.
And your statement that you said was that if I, as their attorney, gave them advice to do what your hypothetical is suggesting, in this situation, the client asked me to handle, because of the lease, the violations of the lease and the threats that the Fixing Housing made before they filed this action, when we had to file the action in circuit court. Because of the threats, she wanted to have, my client wanted to have everything I's dotted, T's crossed, so that he would not be able to claim that she had not done what tenants are allowed to do, which is, if the landlord does not make necessary repairs, which are the terms of the lease, the tenant is allowed to withhold rent, take on the repairs themselves to make the place safe for their boarders and their horses.
What's the operative word you're using in that whole statement?
Pardon me?
What's the operative word you're using in that whole statement?
The operative word is,
Assuming you're correct on the law, which is a little bit iffy, but that the tenant may.
she asked me to make sure that he wouldn't be able to proceed on his threats. And I agreed to just oversee the,
No, you did more than just oversee.
well,
That's the problem.
and Your Honor, what, in this situation, we're here before you. We requested at our last hearing for you to set up an escrow account, a trust fund with the court to accept rent going forward.
So I understand that. I know what I did.
Mhm. That's what we're here to move forward with. Are you not going to allow me to represent my clients going forward?
Ma'am, I've not had a motion to force an attorney's withdrawal in this case. If I make that decision, then I certainly can make that decision on my own motion, but I don't have enough before me that I would feel comfortable making that decision. It is a monumental decision if a court directs that to happen. I will say, Ms. Toe, I'm concerned as to whether or not that's where we end up.
That will, excuse me, I didn't hear.
I'm concerned that that's where we may end up.
I share that concern. I would like to know how you would like us.
Well, I'm okay. So here's what I'm going to do, folks. And I really don't like delaying things. I like to try to keep things moving along. But Ms. Toe, because of the things that I've said, and I think you need to take what I'm indicating to you very seriously. Because there's no reason for me to I really don't have a dog in that fight. There's no reason for me to say it other than the fact that you're facing jeopardy on a number of different levels. And so I'm going to do this. And I realize that it delays plaintiff, but I think the court is compelled to do this. I'm going to adjourn 1 week to the 21st at 3 p.m. And the basis upon which I'm adjourning is I think, Ms. Tope, you need to get the advice of counsel
Got it.
as to how you should move forward and if you should move forward.
Got that.
I also think, although I'm not ordering the defendants to do it, because I can't do that. I might suggest to you that if you've listened to what I've said today, if you believe in your interest to seek the advice of other counsel as to how you should proceed, I'm also giving that week for you that opportunity, should you so choose to do so, for you to do that. I'm not advocating for or against that. I'm just saying I'm giving you the opportunity so that you can make that decision, get based upon what the court has said. Okay? Anything else?
As I said at our hearing on last Friday, I'm scheduled to leave town for Thanksgiving vacation on the 20th.
Ms. Tope, I know, but I
Okay,
don't know what
can I appear by Zoom?
you can submit the paperwork. I don't know if I'm going to allow it or not. I'm not answering that right now. I mean, because I don't know on what, quite frankly, from week to week with this case, I'm not sure in which capacity you're going to be appearing. So you can submit the paperwork and then do that. I'll leave it there. I mean, I have a lot of concerns here for folks. I just do. Anything else from the plaintiff?
Your Honor, just so it's on the record, the court doesn't need to untangle the mess with Ms. Tope's accounting. But as the court correctly stated last Friday, the lease language is non-conditional. Tenants are required to pay base rent of $5,500 per month without any deduction or set off whatsoever. There's no factual dispute that tenants have withheld rent. They admit it. And longstanding Michigan case law in the commercial context, tenants' duty to pay rent is independent of landlords' alleged covenants to repair.
Okay. So what do you want me to do with that?
Say, to avoid untangling that mess.
Well,
it's clear.
No, but here's the thing. And there are certain, and I get what you're indicating, but I'm in a different boat. Understanding what you're saying is if a tenant recognizing their covenant to pay simply withheld the rent to try to get the landlord to do something. That's a different posture. Maybe they can do that. Maybe there might be a breach of contract in that regard. Whatever. In theory, that wouldn't be allowed either, right? But we have another problem here because not only was that part done, but as I'm to understand, then those funds were then dispersed elsewhere. That creates a whole different ballgame. It creates a whole different ballgame, particularly where you're claiming a breach as to who did it. right?
Yes.
And
Yes, sir.
that, so while I recognize and understand what you're saying,
Your Honor, I would.
it's all a mess, and they're sort of a mess on both sides. Less of a mess over here, more of a mess over here. I gotta try to clear that mess before I can even begin to deal with that. I've always wanted to use mess as a legal term. Go ahead.
It may be a term of art. I would just say it's the mess that's being caused by tenants, and they're responsible for the actions of their agent, is causing my client prejudice where he's not getting paid any rent, and tenants are operating their business on my client's property rent free. So my client is the one who's being prejudiced by the mess.
And counsel, I'm well aware of that, which is why I'm trying to at least make some decisions, understanding the other action that was going on, but make the decisions within the confines of this month, which is why I'm not moving beyond. I realize that there is prejudice to your client, at least in terms of the funds being there. As I'm sure you understand, the other issues over here, I've got to deal with, because I think unless they're cleared up, it's going to be even more prejudice to your client, because you're going to be Don Quixote in terms of who you're trying to argue against.
Understood.
And that has to be solved. That's also why, despite Miss Tope's travel plans, I'm not going to my next date of December 5th.
Okay.
Because I don't know that come the 21st will resolve anything. But I got to give that opportunity over here. I have to allow that to occur, I think, in fairness, and just to make sure that the proceedings are what they are.
Understood, Your Honor.
Can we address the order that you gave to set up an escrow account and how much should be put in it? Because the plaintiff in this case was paid $3,600 and some dollars for the rent on November 1st. Are they to put that into the court-ordered escrow account?
What I ordered at the last hearing on the 7th,
Mm-hmm.
the monthly rent is $5,500,
Yes.
correct?
Correct.
What I ordered was that $4,125 was to be placed in escrow by the tenant.
By today,
Yes.
right. Is that
And then $5,500 going forward. Pardon?
Is that the November 1st rent payment, or?
I prorated November.
Okay.
That's how I get $4,125.
Okay. So the check that they got for 3,000 some hundred needs to be put into escrow.
So where's the 3,000 come from?
November rent, and the only amount that was withheld for necessary repairs was taken out of that. That is, my accounting is, I beg to tell you, it's not a mess. The accounting is very clear, and the exhibits for every invoice that was paid is very clear.
Okay. So the last time we were here, and I can't recall independently what the amount of the check was. Did you receive that check?
Your Honor, yes, we received it yesterday. And we sent a reservation of rights letter to.
Okay. So that was for how much?
$35.08 and 96 cents.
Oh, for Pete's sakes.
It was sent on November 1st before you made your order to prorate. So we are prepared to make the difference.
And the deduction from that are
Yes.
what?
It was, the temporary repair of the leaking spigot out in the pastures before frozen ground. And we asked them to please repair it, and we got no response. And
Okay, hold it,
you know, the ground
hold
froze
it.
last week.
Well, it didn't really freeze last week.
Well, it would not, it would have frozen in the
Michigan,
spigot out in the.
that was not a freeze.
It was 27 degrees for 2 days.
I know what the temperature was. I'm just telling you, it was not a freeze of the ground.
There was frozen ice in the bucket.
Oh, for Pete's sakes, all right, fine, it's frozen ground. I don't care. That was not we had frost.
For a spigot out in a pasture to give water to 1,200-pound horses, 35 of which are on the property, we needed to have a fixed spigot that wouldn't freeze. And that's what was withheld from the $5,500 rent due 11/1.
Let me ask you this. Did you cash the check?
I told my client not to cash the check because I knew about this hearing and we had to send our reservation of rights letter. So we still have it. It would seem like triple, prejudice if he now has to give it back. And I don't understand really why opposing counsel decided to release this amount. I don't know, Your
I
Honor.
don't either.
It's in the accounting that
And
was
it-
filed.
It came right before our motion to compel payment of rent hearing.
Here's what
I will leave that there.
I'm gonna, you know what? Ms. Tobe, I don't believe that on the face of it, your clients had the right to withhold any portion of that base rent. On the face of it. Now, it may turn out once everything's litigated, something else comes out in the wash, but on the face of it, they're not entitled to do it.
They asked him to repair the middle of October.
Okay.
Got no
You keep
response.
saying that to me. I don't know why people don't think I hear. I hear everything. You saying it to me over and over again doesn't make it more true. I hear you. I can hear all kinds of people. I do it every day. That doesn't mean that I agree with you. So, since, as I see from this, just the lease language itself, that they would not have been entitled to do that. Plaintiff may do what they wish with what they got. I am not changing my order of November 7th so that the 4125 must be placed into escrow with the court and then 55 each month. If it turns out, so that your clients understand in the end that what you were doing was all, then seeing the accounting and I'll do the math and we'll figure out what needs to be paid or what gets credit. We'll figure that out in the end. But at this point, 4125 is expected to be an escrow.
Paid by my clients. What about the check that they received? Is that to be returned? Not,
No,